Hello, I am attorney Carol Avard. My law firm has been practicing Social Security disability for 38 years. 4 of the attorneys in my firm are board certified in Social Security disability, and we have lectured for numerous professional organizations across the country on Social Security law. If you are applying for Supplemental Security Income, or SSI, this video will explain how Social Security may take away money from your monthly check and reduce your monthly check to an amount that you cannot live on. It will also explain how you can get the maximum amount of federal benefits under SSI, which in 2019 is only $771 a month for an individual and $1,157 a month for a couple. Most important is understanding the concept of holding yourself out as a married couple. It is not what you think it is. The concept applies to both same-sex couples and opposite-sex couples. If you hold yourself out, you will get less money in your monthly benefit check. Social Security considers boyfriends and girlfriends as a married couple if they are living together. Married couples get less money than individuals in the SSI program. Social Security does not care that Florida does not recognize common law marriages. It does not matter what sex you are. 2 women who hold themselves out as significant others can have their SSI checks reduced because they are considered by Social Security as the equivalent of having a common law marriage. Social Security will ask for copies of bills that show both names on them or ask for other papers with both names. If you don't hold yourself out, then make sure bills are only in one name and not both names. For example, your electric bills, water bills, bank accounts, deeds, insurance policies, credit cards, newspaper subscription labels, statements from friends or relatives, neighbors can be used to show you are not holding yourself out. The difference in the maximum benefit is significant, as will be explained later. Therefore, if possible, it is best to say that you are friends and not a couple, and you live independently of the other person. To live independently, you may buy your own food. You may not participate in making household decisions. You may have your own bank accounts. You may even have a separate entrance to the household. You may eat out at McDonald's, for example. Living independently of the other person will allow you to get the maximum benefits from SSI. First, SSI is not the same as SSD. There are no deductions on SSD. SSD is based on federal FICA taxes that you paid to the government during your employment in jobs, but SSI does not depend on any work activity. It is similar to welfare, and it is paid to people who are disabled and who did not work enough to have quarters of coverage accumulated as a result of paying in their FICA taxes for SSD eligibility, or it is paid to the elderly to supplement their retirement checks up to the maximum federal benefit amount that SSI pays out. Before you file your application for SSI, you need to know the following so that you can answer the application questions intelligently. Again, the most you can get in 2019 is a maximum of $771 for an individual and $1,157 for a couple. The amounts go up each year. These amounts are higher in certain states that supplement the $771. For example, a supplement of $887 above the $771 federal benefit rate can be made in North Carolina, and $694 above the federal benefit rate can be made in New York. The monthly benefit can be reduced when there is income coming into the household for food, shelter, or utilities. However, a small but limited amount of money cannot be deducted from the SSI checks. These amounts are called exclusions. If the income is unearned, which means it could be another public benefit like welfare, pensions, child support, Social Security, workers' comp, VA benefits, or unemployment compensation, $20 will be excluded from the unearned income. But if the income is earned income, for example, wages, a higher amount of exclusions applies, and this amount is $65. This $65 gets deducted from the gross earned income. Because Social Security likes people who work, Social Security also deducts 50% of the gross earned income. Furthermore, if the $20 unearned income deduction is not used because there may not be any unearned income, the $20 exclusion can be added to the $65 exclusion on earned income, amounting to $85. After that, only 50% of the earned income counts toward any deductions on the SSI federal monthly benefit rate. Social Security also looks at what they call resources to see if they exceed certain maximum amounts that would be allowed an SSI applicant. The excess is a disqualifying factor. The maximum resource amounts are $2,000 for an individual and $3,000 for a couple. What is a resource? It can be cash, liquid assets, real or personal property, bank accounts, mortgages, mutual funds, or liquid assets valued at fair market value, minus any liens or encumbrances. Resources that do not count are called excludable resources. They include a home that is lived in, personal effects such as furniture, TV, carpets, cooking utensils, dishes, jewelry, wedding rings, books, stereos. One automobile is also excluded regardless of the value. Since the most expensive automobile in the household that is used for transportation does not count, you should always make sure to tell Social Security that is the automobile you are using as the exempt auto. A second automobile, unfortunately, can only be excused if it is valued below the maximum resource limit of $2,000 for an individual and $3,000 for a couple, and you have not already used up the $2,000 limit or the $3,000 limit. A second piece of real estate may be excluded if it cannot be sold on the market or a person living in it would suffer a hardship. There is a 9-month disposal period after which the value of the house will count as a resource, and that may disqualify you from benefits. This 9-month period can be extended in certain circumstances. The house will need to be placed on the market, have a for sale sign on the property, and any offers that are reasonable will have to be accepted. You also need to understand how the reductions on the amount of an SSI check apply and do not apply. For example, you can have a loan agreement with people who give you income. It can be real income or in-kind income, such as free room and board. But all of this can potentially be excluded as income if you have a bona fide loan agreement for a reasonable amount that you can pay back at some future time. Your attorney has loan agreement forms that can be used for this purpose. However, you cannot make the loan agreement solely contingent on winning your SSI case, since you may not be awarded SSI benefits. Use the sample loan agreement forms that your attorney has to be sure you comply with the law to avoid deductions. You do not want to be living for free in a household without a loan agreement. The value of the free use of that space will be deducted and counted as in-kind income. There are no deductions on the SSI benefit check when all other members of the household are on public benefits such as welfare, workers' comp, veterans benefits, and the like. IRWE expenses. These are impairment-related work expenses. These expenses do get deducted from your countable income. They include things like a wheelchair, or like a service dog, or a transportation to and from work. Note, the IRS allows 58 cents per mile. So if another person has to drive you to work and pick you up, you can total the miles times 58 cents per mile and deduct it from your work earnings. Just like you can deduct the cost of a service dog or the dog's vet bills from your work earnings. You can also deduct attendant care services if they are needed in the work setting or in assisting the person to get to work. Attendant care services given at home are deductible if they relate to preparations for going to work. For example, services provided to you such as bathing, dressing, cooking, eating, administering medications, immediately preceding the person's departure for work or following his return from work can be deducted from earnings. These services should not require more than 2 hours in the morning or in the evening. Tax refunds are also not counted as a resource. Bills that are paid by a third party directly do not count as income if not used for food or shelter. For example, if somebody pays your telephone bill, your TV, cell phone, medical bills, it will not count as in-kind support and maintenance or income. As long as it is not used for food or shelter, it will not be in-kind support. Living arrangements are used to reduce your check. In-kind support and maintenance is considered unearned income, but restricts the value to 1/3 of the current federal benefit rate if the person is living in another person's household. There are 4 types of living arrangements. One is living in your own household. This entitles you to the full federal benefit less any reduction for countable income, which includes in-kind support and maintenance. We'll call this the A arrangement. Number 2 is living in the household of another. Here you would only get 2/3 of the federal benefit rate, less any reduction for countable income. We'll call this the B arrangement. Number 3, a child under the age of 18 or a student 18 to 22 living in the household of a parent. This person is entitled to the full federal benefit, less any reduction for countable income, including in-kind support and maintenance. We'll call this the C arrangement. Number 4, individuals living in public institutions where Medicaid pays over 50% of the cost. A small amount of $30 a month less countable income is what this person is entitled to. Call this the D arrangement. Regarding the A arrangement, it applies if you have an ownership interest in the house, or you have a rental liability, or you pay a pro rata share of household expenses divided by the total number of people in the household. All people in the household receive public benefits. If that is the case, then there is no deduction. You prepare your meals separately. That is another factor. You contribute income sufficient to meet your share of either food or shelter costs. You eat your meals elsewhere, you purchase food separately, or you are transient. This makes you living independently of others. Regarding rental agreements, if you pay 1/3 of the federal benefit rate plus the $20 exclusion, SSI will generally not reduce your monthly SSI check for in-kind support and maintenance. Or if you pay rent equal to or greater than the current market rental value, it generally will avoid an ISM reduction. But if the current market rental value is, say, $1,000 and you only pay $700 for rent, there's a subsidy of $300. The $300 would be considered income to you and cause a deduction in your SSI check. Sharing is considered by Social Security a factor. It basically means household expenses divided by the number of people in the household. For example, say there are 5 people in a house and a household has expenses of $1,435. You would divide that by the 5 people in the house and it comes to $287. Household expenses are only those used for shelter and food, and those include electricity, gas, water, sewer, garbage removal, heating, property tax, rental payments, or mortgage, and food, but food stamps do not count. Note that in sharing arrangements, you can use a loan to pay the expenses. The loan can either be oral or written. When sharing or paying your pro rata share, there are no deductions on the SSI check. In summary, when you live independent of other household members, this generally means you buy your own food or you give money to another household member to buy your separate food since you are diabetic, or you do not make decisions about food or shelter, or you may live separately in the same household. You pay a flat fee per month. This results in no deduction. But if the SSI recipient does not pay any rent but buys his own food, this results in in-kind income for support and maintenance. There is a deduction for the value of the free rent, unless there is a loan agreement. If bills are paid by a third party directly, this results in no deduction. For example, for non-food or non-shelter costs like a cell phone, newspapers, telephone bills, home repairs, water heaters, tax refunds, payments for medical care, 1/3 of child support payments, impairment-related work expenses, or anything else that is not food or shelter will also be deducted. In-kind support and maintenance is not cash, but is food, shelter, or clothing. For example, any food, clothing, or shelter that is given to you like free rent, groceries, clothing. This is countable income. Rent amounts. When figuring these amounts, they must be made at the current market value, or it is considered income and would be deductible. For example, the landlord's rental has a market value of $1,000, but charges SSI recipients only $700. You would subtract the $700 from the $1,000, and the amount of $300 would be considered support and income that could be deducted from your SSI check. In-kind support and maintenance depends on the type of household the SSI person lives in. If you are living in another's household, as we discussed above, and you receive both food and shelter from that person, the federal benefit rate is automatically reduced by 1/3, regardless of the actual value of the food. So if the federal benefit rate is $771, 1/3 is $257, and that amount gets deducted from the $771. As I explained before, the exception to the 1/3 deduction rule would apply when you pay your pro rata share of the household expenses to the owner or renter, since you would be considered to be living in your own household and not the household of another, and not receiving any in-kind support. But again, if you are paying less than your pro rata share, The difference is deducted from the federal benefit rate. For example, shelter costs are $1,000 a month. There are 4 people living in the house, and one of them is on SSI. SSI recipient contributes $150, but it should have been contributing $250. So $100 will be deducted from the SSI check. If an SSI recipient does not receive food and shelter from those he lives with, no 1/3 reduction applies. If income can be deemed, for example, from a spouse to a spouse or from a parent to a child, no other deductions are allowed. If in-kind support maintenance comes from outside the household, for example, a third party pays some of the bills, in-kind support will be attributed to you unless it is used for household operating expenses. These third-party outside the household contributions are apportioned equally among all household members. Therefore, things that are not in-kind support are public assistance, HUD subsidies, payments not household operating expenses, or fuel assistance. When dealing with spouse-to-spouse deeming rules, you first apply the income exclusions of $65 per month on earned income, then divide by 1/2 and $20 per month of unearned income exclusion. If $20 is not used, you can apply it to the earned income. This is the countable income. Take the federal benefit rate for a couple, which is $1,157, and subtract the total countable earned and unearned income. Note, the SSI claimant can never receive more than the federal benefit rate for an individual, which is $771. With regard to the parent-to-child deeming, it generally stops at age 18. The parent must live in the same household with the child. For example, if the mother earns $1,040 a month and the SSI child has no income, $1,040 plus the $20 exclusion plus the $65 exclusion equals $85. Subtract that and you get $955. Then divide by 1/2 and you get $477.50. 771 is the federal benefit rate minus the 20. That would amount to 0, so there would be no reduction in the federal benefit rate. When SSI claimants win, they generally have a large retroactive benefit check. However, they are not allowed to receive it all at once. Rather, they receive the money in installment payments of retroactive benefits, and these payments must be made in 3 installments and at 6-month intervals. You should also know a little about the new ABLE accounts. ABLE stands for Achieving a Better Life Experience. SSI people can manage a bank account without a penalty against eligibility for SSI or Medicaid, but the claimant must be disabled before reaching age 26 based on Social Security law, and 2, have only one ABLE account, and 3, anyone can put money in the account, including the SSI owner, and 4, the money is capped at $15,000 in 2019. The account limit for those who do not qualify for SSI is $418,000, or $100,000 to maintain eligibility for SSI. And the money can be used for basic living expenses. $100,000 is disregarded by SSI, but assets above $100,000 count as a resource. If you have any questions, or if you would like us to provide you with the loan agreement form, just ask the attorneys at Avard Law, and we will be happy to assist you. Thank you.